Bernard said it at the wake. In the kitchen, while Marco's colleagues were still in the living room, he said it the way he said everything he meant, not loud, not soft, but with the full weight of a man who has spent 40 years deciding things and expects the room to confirm his decisions. She married for money. He glanced at Socorro when he said it, as if checking that she had heard, as if confirming something they had long ago agreed upon. Then he looked at the casserole dishes and the borrowed folding chairs and the people moving through the rooms of the house Marco had spent 3 years loving into shape. She'll walk away with nothing. She has no claim here. I was standing at the counter with a glass of water I had not drunk. I set it down. I did not say a word. What Bernard did not know, what none of them knew, standing in my kitchen on the worst Friday of my life, was that 3 weeks later, a woman named Delphine Quan would call me on a Tuesday morning and tell me that Bernard's brokerage account was worth $5.1 million and that Marco had put my name on it. 11 years before any of us would need that to matter. Good day, dear listeners. It's Lena again, and I'm so glad you're here with me today. Before we begin, please take a moment to subscribe to the channel and tap the like button. It helps these stories reach the people who need them. And tell me in the comments which city you're listening from. I love seeing just how far these stories travel. And today, I want to ask you something specific before we begin. Has anyone ever told you that you had no claim to what was already yours? Drop your city and your answer in the comments. I read every one. People always say that grief and money should not arrive at the same time, that financial matters should wait for the appropriate distance from loss, that there is something unseemly about numbers when the wound is still new. But here is what 11 years of patient financial counseling taught me. Loss does not negotiate timing. The paperwork does not wait because it is not capable of sympathy. A beneficiary form does not check the calendar before it activates. It simply is what it is. It sits in a file in a financial advisor's office with a name on it that someone chose on an ordinary day. And then it waits. It waits with the patience of something that has no idea it is waiting. Have you ever thought about that? About how much is decided quietly on unremarkable afternoons by people who have no idea the decision will matter? The form does not care. The form simply holds the name. The question, when the call comes, is whether you are the person who can read the number on the page while the grief is still so raw it hasn't yet formed a shape. I had spent 11 years training for that particular skill without knowing I would one day need it for myself. That is the kind of irony that doesn't feel like irony while you're living through it. It only becomes clear later, when you're sitting very still at a kitchen table with a notebook open in front of you and a number written in your own handwriting, and the morning light comes through the window the way it always does, and nothing in the room has changed, and everything has. Marco and I met in a hospital waiting room. He was there for a minor hand injury from a job site, a gash across 2 fingers from a piece of sheet metal that was serious enough for stitches and nothing more. I was on a patient counseling shift, making rounds through the waiting area. He had a way of making waiting rooms feel temporary, not cheerful, exactly, more like he had decided the waiting was simply a condition of the afternoon rather than an indignity to be endured. That decision was so settled in him that it spread, slightly, to the chairs nearby. I noticed it before I noticed him, which I have always thought said something true about both of us. We talked for 12 minutes while he waited for the nurse to call his name. He asked what I did, and I told him, and he said it sounded like a job that required a steady hand. I said I supposed it did. He gave me his number on the back of a business card that read Marco Reyes General Contracting in a font slightly too large for the card. I called him 4 days later. He answered on the first ring. Do you know that feeling? The one where something ordinary is beginning, and you don't know yet that it's going to be the central thing? We married 2 years later in a backyard ceremony in South Tampa, under a sky that had been threatening rain all morning, and then held off as if out of courtesy. Bernard sat in the third row with his arms crossed, and an expression I had already learned to read, not disapproval, exactly, something closer to suspended judgment rendered as its visual opposite. Socorro sat beside him and whispered something to the woman on her other side. I decided, on my wedding day, not to try to hear it. I had made that policy early in my relationship with Marco's family. Decline to absorb commentary you have not been directly addressed with. The policy served me well for 14 years. Marco's family had a way of talking about money that was really a way of talking about worth. Bernard had built his commercial laundry operation in Ybor City from a single van and one hotel contract that had taken him 2 years to land, and he considered that origin story the measure of all financial legitimacy. I was a hospital employee with a salary in the mid-50s and a pension plan I had been contributing to since I was 26. In Bernard's taxonomy, that was not money. That was payroll. And the woman earning it had, in his view, married above her financial station. You might wonder how a person lives with that assessment for 14 years. You manage it the way you manage most things that are not your problem to solve. You go on. You do the work. You stay in the room. We bought the bungalow on a South Tampa street through a client connection of Marco's, a quiet sale, before the listing, at a price that made sense because Marco knew what the renovation would cost and didn't flinch. The screened porch was the first thing we tackled. It had been sagging at the corner, the screen pulling away from the frame, and Marco spent 2 weekends rehanging it and releveling the floor joists while I painted the ceiling a color called heron gray that we had spent 40 minutes in a paint store debating. We put a small table out there and 2 chairs from an estate sale. And in the evenings when the Tampa heat had finally relented and the air smelled of salt and cut grass, we would sit with something cold to drink and talk about the week the way people do when they are still paying attention to each other's weeks. That porch was the place I loved most in the house, in the side yard just off the porch. Marco had planted a Meyer lemon tree the second summer we lived there, a small, squat tree that never produced more than a handful of fruit per season. It had no business being there in terms of output. But Marco visited it every morning on his way to his truck, the way other men check the weather on their phone. He would look at it for about 15 seconds, touch one of the lower branches if something new was happening, and then get in the truck and go. I never asked him why. Some things between people do not require an explanation to be understood. I had worked as a patient financial counselor for 11 years by the time Marco died. Patient Financial Services Counselor was the full title. The job, in plain terms, was to sit with people on some of the worst days of their lives and help them understand what their illness or injury was going to cost, what the options were, what the paperwork meant, how to apply for the programs that existed to help them. Have you ever sat in a hospital consultation room and tried to absorb numbers while the fear was still running through you? I sat across from people in that state every working day. I became, by professional necessity, the calmest presence in most of those rooms. I knew how to read an explanation of benefits form. I knew the difference between a primary and a contingent beneficiary on a life insurance policy. I knew what a succession designation meant and under what circumstances it would activate. I knew this the way a plumber knows pipe fitting, Not because it was glamorous, but because it was the material of my work and the people across my desk were counting on me to know it before they had to. I carried a small notebook and a good pen in my bag every day. I took notes in every patient consultation, the same way a physician takes notes, not because I would forget, but because the act of writing made the information real for the person sitting across from me. It said, "This is real, and I am taking it seriously, and you should too." Marco fell from a roof in September. He was 42 years old and had been in construction his entire working life. He was careful, methodical, the kind of contractor who checks the weather before a high work day and makes his crew check it again. It was an equipment failure, a harness connection that should have held. He was airlifted to the hospital where I worked, which is the kind of coincidence the mind does not know how to absorb for a long time. The building where I sat with people in their worst moments was the building where I received the call about mine. I was in a consultation when my phone buzzed. A colleague finished the session for me. I walked down a hallway I had walked 1,000 times and arrived at a set of doors I had directed families through without ever imagining I would go through them myself. Marco died that afternoon without regaining consciousness. He was 42 years old. We had been married for 12 years. He had loved one house and one lemon tree and the particular quality of a Gulf Coast evening. And he was gone. The wake was held the following Friday at the bungalow, in the rooms we had renovated together. People came from every part of his life: crews, clients, cousins, neighbors, people I recognized, and people I didn't. I had organized the food, the chairs, the flowers, the thank you cards that would go out the following week. Organizing was what I could do while the grief was still in the form of a task rather than a feeling. I wore black and stood at the door and greeted every person by name if I knew it, and thanked them for coming. I meant it. People had stopped their ordinary Fridays to sit in rooms that smelled of Marco's absence, and that deserved acknowledgement regardless of what was happening inside me. Bernard arrived mid-afternoon with Socorro, with Ernesto, Marco's younger brother, and with a cluster of aunts and cousins I knew by sight. He moved through the room with the deliberate pace of a man who believes the space is aware of his presence. He shook hands with Marco's colleagues. He accepted condolences with a dignity that was genuine. He had loved his son. In the particular and limited way that certain men love their sons, completely, with great difficulty in the expression of it, he had loved Marco. I watched him from across the room and felt nothing complicated about him in that moment. He was a father whose son was dead. That is the simplest grief there is. 2 hours in, he went to the kitchen. Socorro followed him. I came through the hallway door with an empty pitcher, heading to the sink. He was facing away, toward the window above it, the window that looks out onto the side yard, onto the lemon tree. I heard him before he saw me. In the voice he used for announcements, "She married for money." Socorro made a small sound of agreement. "Then she has no claim here. She'll walk away with nothing." I stood in the doorway. I held the pitcher. I do not know if he was aware I was there. I do not know if it mattered to him. I stood there for a moment that lasted longer than it should have. Then I set the pitcher on the counter. I picked up a glass of water someone had left and held it without drinking. And then, because Marco's colleagues were audible from the living room and those people did not deserve to witness whatever would follow if I responded, I set the glass down, turned around, walked back through the hallway, and spent the next 2 hours greeting the remaining guests, thanking them by name, making sure that when the last car pulled away from the street, nothing on my face gave any of it away. Then I went to the screened porch. I sat in Marco's chair, the one closest to the door, the one he always took. And I cried in the way you cry when no one is watching. Not quietly, not with any composure at all. The salt air was in from the bay. The lemon tree was a dark shape in the side yard. The porch light was on, attracting moths that hit the screen in small rhythmic taps, and I cried until the grief had run through me enough to breathe evenly again. Then I sat very still, and I thought, with the particular clarity that sometimes arrives after that kind of crying, about what no claim here actually meant. Bernard expected his estate to pass through his will to his surviving children. He was likely correct about the will. I had no claim to Bernard's estate as a surviving in-law, not through intestate succession. Not through any document I had signed. I had no particular expectation of anything from Bernard. Our marriage had been mine and Marco's. That life had been enough. That life had always been enough. But I had also spent 11 years knowing that the paperwork always says something. And I had not yet read all the relevant documents. That is not a dramatic thought. It is simply the thought of a woman who knows that what the form says is not always what anyone expected when they signed it. I went inside. I went to bed. I did not sleep well, but I lay still, which is its own kind of rest. And in the morning I got up, made coffee, opened my notebook, and wrote a list of the practical things that needed to happen in the following weeks. The marital estate was modest. I was clear-eyed about what it contained. The bungalow carried approximately $140,000 in equity, based on comparable sales and what we had put in. The joint savings account held $31,000. Marco's work truck was a 2019 model that would need to be assessed as a business asset. Under Florida intestate succession, my share of what we had built together was straightforward, and I knew the number it would produce, a respectable number. The number 2 people accumulate when they spend 14 years working and renovating and paying off a mortgage, not nothing. But not the number Bernard was talking about when he stood in the kitchen and delivered his verdict. His commercial laundry operation had been grossing somewhere between $800,000 and $1. $1 million annually for the past several years. I knew this in the way you know things that drift into family conversation over 14 years of dinners. Not as facts anyone states directly, but as the pressure behind certain remarks about contracts and expansion and which cousin had been offered a position and had turned it down. The Ybor City building he owned outright. The contract with the hotel group that had grown from 1 property to 11. Whatever he had accumulated in 40 years of building something from a single van, I had never thought it was mine to count. It was his. He had earned it. I had never asked for it or expected it or wanted it to be otherwise. What I had was the house and the joint savings and the marriage. And that had always been the whole inventory of what mattered. What he was declaring, that I had no claim here, referred to his own estate. His commercial laundry business, his building in Ybor City. Whatever he had accumulated over 40 years that he intended to leave to his children. He was correct that I had no claim through his will. I had never asked for one. I had never expected one. What I had not yet done was read every document in the chain, and what I held in those first weeks was not certainty about any outcome. It was a professional habit. The habit of knowing that you have not yet read all of the relevant papers, and that there is always one more document. The first sign that Bernard intended to act on what he believed came the morning after the funeral. Ernesto called me during the middle of the morning, not with urgency, but with the particular gentleness that I recognized from patient consultations, the gentleness people use when the question underneath the question is financial. He said he was calling to check in, to see how I was doing, to ask if I needed anything. I said I was managing, thanked him for calling, asked about his wife and children. There was a pause that lasted slightly too long. Then he asked with careful warmth whether I had thought about what I would do next. He meant the bungalow. He meant housing. He meant the estate. He dressed it as concern. Maybe a fraction of it was concern. But the inventory underneath it was not. I said I had not yet had time to think about next steps. I thanked him again. I got off the phone and wrote in my notebook, Ernesto, check and call, 10:18 a.m. What will you do next? I drew a small box around it. Do you see what I mean about the paperwork? The boxes in the notebook are their own kind of document. The second sign came 2 days after that, and it was documentary rather than conversational, which is exactly why it was the more important clue. An email arrived in my personal inbox from a Tampa estate attorney I had never contacted, had never heard of, and had never been referred to. The email was addressed to me by my full name, not a form letter greeting, but my actual name, and offered a complimentary surviving spouse consultation to discuss my legal options in the estate process. No one I knew had referred this attorney to me. Someone had referred the attorney to me. The email read like the first movement of a larger document, the kind of document a family sends when they want a signal, gently, that they have legal resources available and that you should be aware of them. I read it twice. I saved it to a folder I labeled Correspondence, Estate. I did not respond. Have you ever received something like that? Something that looks like help but is really the first page of a claim? The difference is in what it's asking you to do. Help asks nothing. A claim has a direction. Those two things together, the inventory call, the unreferenced attorney, told me that Bernard's family believed they were managing a situation that required management, that there was an asset or a set of assets they were concerned about, and that they were moving to position themselves around it before I did. I still did not know about the brokerage account. I knew Bernard had money. I knew it was substantial, from fragments of conversation over 14 years, the way money is always present in a family like Bernard's, audible in the silences around certain topics, visible in the things that are not said at dinner. But I did not know the specific number, and I had not yet found the specific document. Delphine called on a Tuesday morning in the third week after the wake. I was in the kitchen making coffee before my shift, in the subdued state of someone who has been waking early for 2 weeks because grief does not permit sleeping in. The phone showed a number I didn't recognize. I answered with my name, clearly a professional habit. She identified herself. Delphine Kwan, financial advisor, calling from a Gulf Coast financial services firm on behalf of a brokerage account in the name of Bernard Reyes. She was calling, she said, to notify me of a beneficiary succession event on that account. I set the coffee mug down. I reached into my bag, already packed for my shift, sitting on the kitchen chair as it sits every work morning, and I took out my notebook. I opened it to the next clean page. I uncapped my pen. The pen I always carry, the same pen I use in every patient consultation. She explained the structure carefully and without hurry, which is the mark of a professional who has done this before. Marco, she said, had been listed as a contingent beneficiary on Bernard's brokerage account as part of an estate planning update executed 11 years prior. I had been listed as Marco's designated successor beneficiary. If Marco predeceased Bernard, the account would pass to me rather than back into Bernard's estate. Bernard had authorized the estate planning update himself. His signature was on the authorization form. He had reviewed the designation at the time and approved it. Marco had predeceased Bernard. Bernard had died 6 weeks after Marco from a heart condition that had been known and managed. The succession chain had triggered. The account had been valued at transfer at $5.1 million. She paused. I wrote $5,100,000 in my notebook, in numerals rather than words, the way I write every amount that matters. I asked her to spell her full name. She spelled it, letter by letter. I wrote it beneath the number. I asked for the name of the firm and the office address. She provided them. I asked what documents I would need to initiate the transfer. She said she would email a list. She said the process would be straightforward given that the designation was properly documented and the succession chain was clear. I thanked her. I told her I would call back before the end of my shift. She said she understood. No urgency. Take whatever time I needed. I sat at the kitchen table after the call ended. I did not move for 20 minutes. The morning light came through the window above the sink, the same window Bernard had been facing when he made his announcement at the wake, and it fell across the table in the way it always does at that hour. I sat in it with the notebook open in front of me and looked at the number. I looked at Delphine's name beneath it. What I felt in those 20 minutes was not triumph. It was not vindication. It was something closer to the feeling I have in the first seconds after a patient begins to cry in my office. A stillness that is not detachment, but is the professional discipline of staying present without being swept. The number was real. The call was real. The name was in the notebook. I had written it down, and written things are the kind of real that cannot be undone by shock or denial. 20 minutes. Then I stood up. I went to work. I called Delphine back from the hospital parking lot at the end of my shift. I had written my questions in the notebook during my lunch break, in the order I wanted to ask them: timeline, documentation requirements. The nature of the designation under Florida law, and the question I most needed answered, whether the designation was subject to any will contest. She answered each one in the order I asked. Under Florida law, a named beneficiary on a brokerage account inherits outside of probate entirely. The designation supersedes any provision of a will. A will cannot reach a beneficiary-designated account. 11 years in place, no amendment, no revocation. Florida statute was explicit and not ambiguous. The $5.1 million was not part of Bernard's estate for purposes of will distribution. It was not accessible to his other heirs through any probate process. It was mine, through the succession chain Marco had established and Bernard had authorized. Have you ever heard a sentence that rearranges the room you are sitting in? Not because it is surprising, exactly, but because it makes visible something that was always there and that you had simply not seen yet? That is what the Florida statute felt like when Delphine read it to me. Not a surprise. A visibility. I asked whether she anticipated challenges from the family. She said she couldn't predict that, but that she was required to notify all interested parties once the succession was triggered, and that she had already sent the notification to Bernard's estate. I asked for 2 names of estate attorneys in Tampa she could recommend professionally. She gave me 2. I wrote them in the notebook. I got in my car. I drove home. I did not call anyone that evening. I went to the porch and sat with the light off and watched the lemon tree in the dark and thought about Marco, who had put my name on a form 11 years ago on an ordinary Tuesday. He had not known. Neither had I. Neither had Bernard. None of us had known we would one day need that form to carry the weight it ended up carrying. The family's response to Delphine's estate notification was organized and quick. 4 days after her notification was sent, Bernard's attorney sent a formal letter to Delphine's firm. The letter requested a review of the beneficiary designation's validity, with a specific inquiry into whether the designation had been properly authorized and whether it could be challenged under Florida estate law. Delphine forwarded me a copy and CC'd the estate attorney I had retained by that point, a woman named Patricia Arriaga, who had a South Tampa office and who had handled beneficiary disputes before. Our first call lasted 22 minutes. She said, in our third minute together, "The designation is valid. It is outside probate. There is nothing to contest." I recognized the tone. It was the tone I use when a patient's family is demanding a coverage outcome that the policy does not support. Calm, clear, not asking for discussion. Patricia's formal response to Bernard's attorney was sent within a week. It laid out the grounds required for a successful challenge to a beneficiary designation under Florida law, fraud, undue influence, or a defect in the execution of the form itself. None of those grounds existed here. Bernard had authorized the estate planning update himself. His signature was on the form. The designation had been in place, unchallenged and unamended, for 11 years. Delphine's compliance team had already reviewed the designation internally and confirmed its validity. The challenges framed had nowhere to go. What did Bernard's attorney do when he received that response? He regrouped. He sent a new letter 8 days later, requesting an in-person meeting at Delphine's office to review the original documentation and confirm the beneficiary chain. Delphine agreed. She offered 2 dates. She also offered to have me present in my capacity as the designated beneficiary if I chose to attend. I chose to attend. The meeting was scheduled for a Thursday morning at 10 o'clock. Patricia and I met in her South Tampa office the afternoon before the meeting to go over the documentation and the order of proceedings. Her office had the look of a place where difficult things are handled with efficiency. Files and labeled folders, a whiteboard with case names and dry erase marker, a credenza with a printer that was running when I arrived. She poured us both coffee, and we sat at her desk, and she walked me through every page of the documentation Delphine had sent, the original estate planning update from 11 years prior, the beneficiary schedule, the annual statement issued the prior January that listed the account value at $4.9 million. It had grown by $200,000 in the 10 months since. She showed me the Florida statute on her screen, the provision that exempts beneficiary-designated accounts from probate proceedings. Have you ever read a statute that felt like someone had written it specifically for your situation? Reading that one, at Patricia's desk the afternoon before the meeting, with the chain of succession laid out in Delphine's certified copy. I felt the particular steadiness of someone who has read all the documents and knows what they say. Patricia asked me whether I wanted to say anything during the meeting or whether I preferred to let the documentation do the speaking. I said I would speak if spoken to, and otherwise let the documentation speak. She said, "Good. That is the right answer. Some situations are best handled the way certain patients handle a difficult diagnosis, quietly, with attention, without performing anything." 2 nights before the meeting, Ernesto called me again. It was early evening. I was at the kitchen table reading through the documents Delphine had sent, the original estate planning update, the beneficiary designation form, the Florida statute sections Patricia had flagged. I answered on the second ring. Ernesto said the family had retained outside counsel and was looking into the situation. He said it with the tone of a man trying to be firm and conciliatory simultaneously, which is a difficult combination to carry. I said I understood. I said all further communications should go to my attorney. And I gave him Patricia's name and number. He was quiet for a moment. Then he said he hoped we could handle this like family. I said I hoped so too. I ended the call. I wrote, "Ernesto, Evening call, retained outside counsel, handle this like family. I underlined the last phrase twice, not in bitterness. Data is data. I went to bed early that night and slept better than I had in weeks. That is what happens when you have read all the documents and the documents are clear. The anxiety that lives in unread pages has nowhere to rest. I lay in the warm gray bedroom Marco had repainted the summer before the accident. He had picked the color from a chipboard without deliberation, the way he made most decisions. Confidently and without agonizing, and I looked at the ceiling and thought about the chain of choices that had produced that Thursday meeting. 11 years ago, Bernard's financial advisor had recommended an estate planning update. He had explained the succession structure. He had produced the forms. Bernard had reviewed them, understood them, and signed them. He had signed a page that named Marco as a contingent beneficiary and me as Marco's successor beneficiary. And then he had gone on with his life, and the form had gone into Delphine's files, and 11 years had passed, and Bernard had simply, in the ordinary way of people who do not carry a notebook, not written it down anywhere he would see it again. I thought about Marco on the day he received his copy of the estate planning update confirmation, a routine envelope from Delphine's firm, most likely confirming the designation had been updated. He would have looked at it, confirmed his name and my name were correct, filed it or not, gone on with whatever that day was. He had not told me. There was no reason he would have needed to tell me then. It was a routine document about a contingent event that neither of us had expected to happen for decades. He had simply done the responsible thing, in the way responsible people do responsible things, quietly, without announcement, in the normal course of taking care of the people they love. I cried that night. Not about the money, about the quiet, unremarkable care of it. The Thursday meeting was held in Delphine's office on the 4th floor of a Gulf Coast financial services building, with a view of the bay that I had not noticed on my first visit, but noticed now when I was no longer in shock. Delphine had arranged a conference table for 6, herself at the head, Patricia and me on one side, Bernard and his attorney and Socorro on the other. Bernard's attorney was a man in his late 50s with a leather portfolio and the manner of someone accustomed to entering rooms with an expectation of outcome. Bernard wore a dark jacket. Socorro wore black. They arrived 4 minutes after we did. I placed my notebook on the table in front of me. I uncapped my pen. The same notebook I carry every day. The same pen. Delphine opened the meeting by stating its purpose, a review of the beneficiary designation documentation on the account, at the request of the estate. She opened a file and placed a certified copy of the estate planning update authorization on the table, centered between both sides. It was a single page. At the top, the firm's name and a date from 11 years prior. In the lower section, a line labeled Account Holder Authorization. On that line, in blue ink, Bernard's signature. Bernard's attorney picked up his copy and reviewed it. He turned to the second page, the beneficiary schedule. He reviewed the schedule. He made a note on his legal pad. Then he set the form down and asked Delphine whether she could confirm that this was the document of record. She said it was a certified copy of the original, which was held in the firm's permanent files, and that the certified copy carried the same legal weight. He asked whether any amendment or revocation had been filed since the authorization. None had. He asked when the account holder had last reviewed the beneficiary designations. She said designations were listed on each annual summary statement and that she could produce the last 5 annual statements if needed. He said that would not be necessary. He turned the legal pad toward Bernard and wrote 2 lines on it. I could not see what he had written. Bernard read it. Then he looked at the form. Then he looked at his own signature on the authorization line. He looked at the date at the top of the page, 11 years ago, an ordinary month, when Marco was alive and none of them had been thinking about succession chains, because why would they have been? Bernard looked at that date and at his own handwriting for a long time. Socorro had been composing herself to say something for the entire meeting. I was peripherally aware of her, the way you are peripherally aware of a pressure system approaching. You don't look directly at it, but you track it. She said nothing. She set her hands flat on the table and looked at the certified copy and said nothing at all. Bernard looked at Delphine. He said, I signed this. It was not a question. He knew it was his signature. He was a man who had built 40 years of a business on his own name and his own word, and he recognized them both on the page. Delphine said, yes. Bernard's attorney asked for a 15-minute recess. Delphine granted it. Patricia and I went to the small waiting area outside the suite. Patricia said, in the way of someone who has watched this particular moment before, he's been advised. The challenge is over. I said I thought so too. I looked out at the bay, which was a flat pewter color in the morning light, the kind of water that looks like it has been smoothed by hand. I thought about Ernesto's call. I thought about the attorney email I had never answered, sitting in my correspondence folder since the week after the wake. I thought about all the documents I had read carefully, and all the documents I had simply known to look for. The paperwork had been saying something the whole time. I had simply waited for all of it to arrive. We went back into the conference room. Bernard's attorney confirmed to Delphine that his client would not pursue a formal challenge to the beneficiary designation. He said it in careful legal language that amounted to no grounds, and we know it. Patricia acknowledged the confirmation on my behalf and asked Delphine to confirm the transfer timeline. Delphine said 4 to 6 weeks for the standard process. No additional documentation required, and that her office would be in contact with Patricia's throughout. She looked across the table and asked if there was anything further to address. There was not. The meeting lasted 43 minutes from the moment Delphine opened the file to the moment Bernard's attorney closed his leather portfolio and stood. I wrote the time in my notebook when it ended, the same habit I use at the end of every patient consultation. Then I wrote, transfer to proceed. Bernard was still seated when I put the cap back on my pen. He was looking at the window, not at the form, not at me, at the window, the way he had looked at the kitchen window above the sink on the day of the wake. But this time, the lemon tree was not in the window. There was only the bay and the pewter water and the morning light coming in at an angle that made the conference table look, briefly, like it was made of something more permanent than it was. He looked at me once before he stood, a direct look, without the estimation that had framed every look he had given me in 14 years, without the categorization, just a look from a man who had come into a room expecting one outcome and was leaving with another. He looked at me, and then he looked away. He looked away before I did. I held his gaze until he released it, and then I turned to say something to Patricia, and the meeting was over. There are things that happened after the Thursday meeting that matter to this story, and I want you to know them. The account transfer took 5 weeks and 2 days from the date of the meeting. I received the transfer confirmation by certified mail and by email on the same morning, a Tuesday, which felt right since Delphine had first called me on a Tuesday. I opened the certified letter at the kitchen table with my coffee, the notebook beside me, and I read through the confirmation document the way I read every financial document, beginning to end, including the account numbers, the reference codes, the form identification numbers in the footer, every line. When I reached the line confirming the full account balance had transferred to my name, I set the letter down and sat with it for a while. $5.1 million. The number I had written in my notebook on a Tuesday morning 6 weeks before, in the same kitchen, at the same table, under Delphine's name. Same handwriting. Same number. Real. Both times. The first thing I did was pay off the mortgage on the bungalow. The payoff amount was $280,000. Not the financially optimal use of capital. Patricia and the financial advisor she connected me with had thoughts about that, and I heard them. But the bungalow was the house Marco and I had built together. I wanted to own it without condition. The clear deed arrived by mail 3 weeks after the payoff. I put it in the same file where I keep all the documents that matter, behind the certified copy of the beneficiary designation that Delphine had sent for my records. I established college savings accounts for my sister Marisol's 2 children, Elena and Tom's, who were 9 and 6 at the time. The amounts I set aside were enough to cover 4 years each at a state university, with room to adjust for inflation, based on the projections Delphine's office ran for me. I made those decisions sitting at the kitchen table with the notebooks and the statements, the same way I make all decisions involving documents. Carefully, completely, without skipping the footnotes. Marisol had not been present at the wake, and did not know the specifics of what had happened with Bernard's family. I had not told her during the first terrible weeks, because she was already grieving Marco in her own way, and there was no reason to load the noise of the family's behavior onto her grief. When I finally told her, over the phone on a Sunday afternoon, she was quiet for a long moment. Then she said, "Marco always made good decisions." I said I had been thinking the same thing for weeks. I donated $100,000 to the hospital's charity care fund in Marco's name, the same fund I had been directing patients toward for 11 years. The applications I had sat beside people and helped them fill out, people who were afraid of what the bill at the end of the hallway was going to say, who needed someone to sit across from them and explain that the number was manageable, that a process existed, that there was help if you knew how to ask for it properly, and where. I made the donation through the hospital foundation office, and the woman who processed it said Marco's name would be added to the fund's annual donor list for as long as the fund existed. I thanked her. I went back to my desk. I have thought about one patient in particular in the years since. A woman I'll call Rosa. I always use different names, you understand, who came to me 3 months before the settlement, when none of this had happened yet, carrying a folder of papers she had been afraid to open. Her husband had a diagnosis that required a procedure that cost, out of pocket, close to $22. 00. She had done what most people do. She had opened the first bill, seen the number, and closed the folder and put it on a shelf. She thought, as many people do, that avoiding the document meant avoiding the problem. I told her, very gently, that the document and the problem are the same thing, and that the only way through the problem is through the document. We sat together for 40 minutes. By the time she left, she had a charity care application in progress, a payment arrangement that reduced her net obligation to under $1,400, and a clear understanding of what each form was and why it mattered. She cried when we finished, not from sadness, but from the relief of things being named. I know that relief. I felt something like it at the kitchen table on a Tuesday morning with Delphine's name and a number written in my own handwriting. Sometimes the document, when you finally open it, says something better than you feared. That was the week I returned to work. I sat at my consultation desk and told a 67-year-old woman about her coverage options for a procedure she needed and was afraid she could not afford. I walked her through the charity care application. I told her what documents to bring, how long the review typically took, what the approval rate was for cases like hers. I used the same voice I have always used, calm, specific, without the particular gentleness that tips into pity, because people who are afraid do not need pity. They need information delivered without condescension and without hesitation. She left with a folder of materials and my business card with my direct extension written on the back and the pen I always carry. The work does not change because the account balance changed. The woman in that consultation had no way of knowing anything about my circumstances, and she should not have had to. She needed what the job provides. The job still provides it. Delphine and I have maintained a working relationship since the transfer. She sends quarterly account statements, and I read them at the kitchen table, in the same way I read all financial documents, beginning to end, every line, every footnote, every form number in the margin. She called once, 6 months after the transfer, not about business, but to check in, the way certain professionals do when they have sat across a table from someone during a defining moment and found themselves with something like regard for the outcome. We talked for 15 minutes about the account, and about nothing particular. She mentioned that she had been Bernard's advisor for 17 years. She did not say anything more about him. She didn't need to. Ernesto has not been in contact since the Thursday meeting. I don't expect he will be soon. Socorro has not reached out. Bernard died 6 weeks after Marco, as Delphine had told me on that first call. The heart condition that had been known and managed had not, in the end, been manageable enough. I attended his funeral, because Marco would have attended his father's funeral, and that reason was sufficient. I sat in a pew near the back, behind the cousins, and I looked at the casket and I thought about 40 years of work and a building in Ybor City, and a form signed on an ordinary afternoon that had ended up meaning something entirely different from what anyone had intended when it was signed. I did not feel anything complicated about Bernard. He had been proud, and he had been wrong, and he had been a man who loved his son in the limited way available to him, and the form was not my doing. Marco had named me. Bernard had authorized it. The financial advisor had filed it. And 11 years had passed, and Marco had died, and the form had done exactly what it was designed to do. I go out to the screened porch most evenings now, when the day has cooled and the air off the bay smells of salt, and the neighbor's gardenia that blooms on the other side of the fence from October through December. I repainted the porch ceiling this spring after everything settled. Not heron gray exactly, a shade deeper that the paint store had in their records from our original purchase. Under the account Marco and I had opened when we first bought the house, the associate found it in under 2 minutes. I said 1 shade deeper, which was my decision, made alone, and the associate mixed it and handed it to me without comment, the way professionals honor decisions that belong to the person making them. The chair Marco always sat in is still on the porch. I don't sit in it. I sit in mine, on the other side of the small table, and I look at the side yard and the lemon tree, which produced 11 or 12 good-sized lemons this year, more than it has ever produced in any single season since Marco planted it. I cannot explain it. I leave the notebook closed when I sit out there. Marco's wedding photograph is on my desk at work. It has been there since a few months into our marriage, and it will stay there. Patients sometimes ask about it during consultations, in the way people make a small human moment before the hard conversation begins. I tell them that was my husband. Sometimes they say he looks kind. I say he was. Then we go back to the documents, because the documents are what I can help with. And the documents are what they came for, and that is the work. Here is what I know, after all of it. The paperwork does not wait. It does not consult the emotional calendar. It does not check whether the wound is still fresh before it activates. What you hold when everything around you is uncertain is not necessarily what you expected to hold. Sometimes it is a habit of reading carefully, a professional muscle you built for other people, on other people's worst days, without knowing you were building it for your own. What would you have done? Would you have said something in that kitchen? Or would you have set the glass down and walked back to the living room? I have thought about it. I have thought about what it would have felt like to turn around in that doorway and say, "Simply, Bernard, you should check the beneficiary designation on the brokerage account before you make any further announcements about what I am or am not entitled to." I did not say it. I went to the porch instead. I cried. I let the moths hit the screen. And the form waited. It had been waiting for 11 years already. It knew how to wait. Bernard stood in my kitchen on the worst day of my life and announced what he believed was a financial truth. He believed it completely, the way a man believes things he has decided rather than verified. He had signed a form 11 years before that made it the opposite, and he had forgotten he signed it, and the form had not forgotten anything. To Bernard, the form was always there. Marco put my name on it, and you authorized it, and neither of you could have known we would need it to carry what it ended up carrying. But it carried it. That is what properly executed documents do. They carry what you put in them, whether you remember putting it there or not. What would you have done? Would you have said something in that kitchen? Or would you have set the glass down and gone back to the living room? Tell me in the comments. I want to know what you would have done. And if you know someone who has ever been told they have no claim to what was already theirs, share this with them. Thank you, always, for listening.